మేడం హలో మేడం మేడం ప్లీజ్ అన్మ్యూట్ మ్యామ్. హలో సుష్మా మ్యామ్. హలో హలో కథ దగ్గర పెట్టుకోవాలి.
నమస్తే సార్.
నమస్కారం.
నమస్తే సార్. రామకృష్ణ సార్ నమస్తే. నమస్తే వీసీ సార్. గుడ్ మార్నింగ్.
గుడ్ ఈవినింగ్ ప్రొఫెసర్ గారు. గుడ్ ఈవినింగ్ వీసీ గారు. అందరికీ నమస్కారం.
Sir, good evening, sir. Ramakrishna sir and G.P. Reddy sir. I'm Dr. Ramneshwari.
Sushma ma'am, is there any delay? I think Honorable Vice Chancellor joined, Professor Ramakrishna joined.
I think they are waiting for Raghavendra, are they?
Raghavendra appears to be a little sick, sir.
Okay.
He is going to join later, little later.
Okay, fine.
So you have to launch and take off.
Okay, sir.
Sushma ma'am.
Sir.
DC గారు రెడీగా ఉంటే స్టార్ట్ చేసేయండి.
అలాగే సార్. అలాగే సార్.
అందరు రెడీగా ఉంటే మన వైస్ ఛాన్సలర్ గారు, డీన్ గారు, రిజిస్ట్రార్ గారు ఉంటే అక్కడ సీనియర్ రిసోర్స్ పర్సన్స్ సార్ కూడా వెయిట్ చేస్తున్నారు.
ఓకే సార్. ఓకే సార్. ఓకే సార్. ఒక 2 minutes సార్. Good evening, sir. Namaste, sir.
Good evening, Andy. We can start now. If everybody is there, we can start.
Yes, sir.
Good evening, sir. Namaskar.
Good evening. Good evening.
Sir, shall I start the program, sir?
Yeah, please.
Yes. Namaste. Good evening to everyone. Welcome to all. And thank you for joining us for the webinar on intellectual property rights in academics and research. Myself, Y. Sushma Priya, Assistant Professor, Department of Physics, Adikavi Nana University, and convener of today's program. Before I begin this webinar, I would like to thank and acknowledge my gratitude to Honorable Vice Chancellor of Adikavi Nana University, Professor M. Jagannath Rao Garu, Registrar of Adikavi Nana University, Professor B. Gangarao Garu, and Principal Dr. K. Ramaneshwari Madam, University College of Science and Technology, for giving me this opportunity. I express my sincere thanks to today's webinar distinguished guest, Dr. G.R. Raghavendra, Joint Secretary, Ministry of Law and Justice, Professor T. Ramakrishna Garu, Chair Professor, DPIIT, Chair on IPR, National Law School of India, and Professor G.B. Reddy Garu, Department Law, Osmania University. And my greetings to Executive Council members, senior professors, faculty of different departments, officials from different fields like research, lawyers, professionals, and my dear students. Once again, welcome to you all. Now, I would like to invite our principal, Madam Dr. K. Ramaneshwari Garu, for the welcoming address of today's program.
A very good evening to the August gathering today. I, on behalf of the Adikavi Nana University and University College of Science and Technology, would like to extend my welcome to this webinar on the intellectual property rights in academics and research. And today I would like to invite all the dignitaries who are here and who have accepted to be amongst us for the conduct of this webinar. And sir, at the outset, I would first like to invite our Honorable Vice Chancellor, Professor Mokka Jagannath Rao Garu, to this webinar today. And in the presence of today's audience, I would just like to tell you that he has taken charge in January 2020. Then we had the COVID lockdown, but because of his relentless efforts, he has been putting the academic striving on the academic ground, and because of his vision and support, the various departments of all the constituent colleges, that is University College of Arts and Commerce, University College of Science and Technology, University College of Education, University College of Engineering, then the two campuses from Kakinada and Tadepalligudem, we have been able to conduct about more than 50 plus webinars in form of different conferences, workshops, and even faculty development programs, because of the motivation and support that our Honorable Vice Chancellor is providing us to go ahead and progress in the academic front. And we have not even left our students alone during this pandemic. We have been supporting them in all different aspects. That is only because of the able administration and the leadership of our Honorable Vice Chancellor, Professor Jagannath Rao Garu. Sir, I welcome you to this webinar today. And I extend my warm welcome, though our Registrar, Professor B. Gangarao Garu is not here, but his support has been always there for us to conduct programs like this. And I extend my welcome to the dignitaries of, to the eminent speakers of today's program. That is, we have three eminent members, Dr. G.R. Raghavendra Garu from the Department of Justice, who is the Joint Secretary, and Ministry of Law and Justice, Government of India. We have Professor T. Ramakrishna Garu, the Chair Professor of DPIIT, Chair on IPR, Postgraduate and Doctorate Council, National Law School of India, Bengaluru, and we have Professor G.P. Reddy Garu from Department of Law, Osmania University. Thank you, sir, G.B. Reddy, sir. Because of you, we are able to arrange this series of webinar, and this is only just a curtain raiser today. And I also extend my welcome to our EC members who are present here, my co-principals, my faculty colleagues, and above all the participants who include the different faculty members, research scholars and students. And I wish the Department of Physics and congratulate the Department of Physics for taking up efforts in organizing a series of webinars on this topic. I take pride in mentioning that this is the first topic that is going for a series of webinars. Thank you, Sushma Madam, for giving me this opportunity.
Thank you, Madam. Thank you very much. Now, it's my privilege to introduce today's webinar chief guest, our Honorable Vice Chancellor of Adikavi Nanna University, Professor M. Jagannatha Rao Garu. Professor M. Jagannatha Rao Garu, Honorable Vice Chancellor of Adikavi Nanna University, Rajamahendravaram, has done his education both in India and abroad. He got his master's degree in engineering from University of Alaska, USA, and he got his PhD from Andhra University, Visakhapatnam in the year 1985. He joined as assistant professor in the Department of Geology, Andhra University in 1986, and later promoted to professor and head of the department from the same department. He is a serious researcher and academician, having more than 33 years of experience in both teaching and research. He has published nearly 150 papers in national and international journals. 33 scholars got awarded PhDs under his guidance. His students are not only from geology, but also from computer science, geoengineering, geophysics, and allied physics. He has strong research collaboration with various organizations from USA, Canada, and Australia. He has completed 8 funded projects from leading funding agencies of this country, including DST, UGC, CSIR, DOD, MOES, ISRO, ONGC, etc. He has a vast experience in administration. He held various administrative positions like Director of Information Management Center, Andhra University, Dean for PG and Professional Examinations, Andhra University, Director for International Student Affairs, Andhra University, Director for Delta Studies Institute, Andhra University, Chairman for Board of Studies, Department of Geosciences, and he filed a patent entitled An Inventive Model that explains the genesis of Bay of Bengal and Arabian Sea, which is under consideration. He got many awards and honors, including Dr. Sarvepalli Radhakrishnan Award, the Best Academician Award of the year 2019 by Andhra University. He awarded Scientist of the Year 2017 by National Environmental Science Academy, New Delhi. He is the member of various professional scientific bodies of national and international repute. He is the NAC accessor and many more. He is a member in various boards of selection committees at national and state level. His earlier selections include UPSC Civil Service Group B Service examination in 1985, UPSC Geologist examination All India 11th rank in 1983. Because of his passion for teaching, he is in teaching life. His vision is to see that Adikavi Nanna University should be the international institute of choice for education, research, training, and consultancy. I am delighted to call upon Professor M. Jagannatha Rao Garu to address the participants. Thank you, sir.
Oh, thank you, Dr. Sushma,
Thank you, sir.
for your nice words of introduction. And I'm very much happy and delighted to be part of this webinar entitled Intellectual Property Rights in Academics and Research. We have here our principal, Dr. Ramaneshwari, Principal, College of Science and Technology. And I'm extremely happy to have our guests today. I am very thankful to all of them for accepting our invitation and for giving their expertise, knowledge, and all the information related to IPR. Dr. G.R. Raghavendra, Joint Secretary, Ministry of Law and Justice, Government of India, and Professor T. Ramakrishna, Professor of Law, IPR Chair, Professor, National Law School of India, and Dr. G.B. Reddy, Professor of Law, Osmania University. I welcome you, all of you, sir. And exactly today, along with our faculty and this convener of this, Sushma Priya and others, we have here other principals of constituent colleges and EC members and faculty and our registrar, Professor Ganga Rao, and all other participants who are there in this webinar. I welcome all of them and my best wishes and greetings to all of them. So when you are, as Dr. Ramaneshwari said, we are all having a challenge of this COVID pandemic, and we're all confined ourselves to homes, which in fact, we have taken these challenges as an advantage, and we start exploring other platforms, how to disseminate knowledge, because being teachers, being educators, we cannot just sit at home in the lockdown. So we need to use the technology. So we have this pandemic given us an opportunity to explore how these platforms can be used to continue our academic activity, to continue dissemination of knowledge to students, even by just sitting in your own office or home, but you can extend all the lessons online to all the students and research scholars and etc. So in the same way, we have also started conducting webinars using the online platforms. So we have almost, as Dr. Ramaneshwari said, we have conducted a number of webinars. Perhaps our university can boast of that we have conducted the maximum number of webinars, more than 60 plus so far. We are going to conduct many more such webinars in the coming days. So I'm very thankful and congratulate all the faculty for actively involving in conducting webinars, right from science, engineering, humanities, management, law, education, etc. So today's webinar topic is the most important of all. I feel it is the intellectual property rights in academics and research. When you talk about intellectual property rights, are the rights given to persons over their creation, the creation of their minds. They usually give the creator an exclusive right of their device or their invention or the model for a certain period of time. There may be many types of intellectual property, and some countries recognize more than others. The most well-known types are copyrights, patents, trademarks, geographical indications, and trade secrets or industrial information. So this is being scientists, being academicians. So we are working on our various research projects. You'll be working on research investigations. While doing so, you may come up with some kind of invention, some kind of device which is not there so far, or you will be developing which is a device in a better way. So you're improving the performance of a device that is already there. So this is all an important thing. This is all intellectual property. So the rights, all those rights should belong to the inventor. So first of all, we should know that being scientists, we should know what is this intellectual property, what is meant by a Patents Act of 1970. So the Patent Act 1970 will tell an invention must fulfill 3 criteria. The first, it must be a new product or a process that did not previously exist, or it must offer a new technical improvement of the existing device, as I said earlier, and it should be useful also. The things you have invented, suppose they are not useful. In fact, they are of a destructive nature, cannot be patented. Suppose they're illegal or they can be used for immoral purpose. So that cannot be patented. For a business, a trademark is among its most valuable asset. So the company's trademark protects its distinctive sign or indicator. It can be patented, like symbol, logo, word, phrase, sound, design, etc. Similarly, a geographical indication, GI, is a tag used on products based on their geographical uniqueness. Suppose we have Tirupati Laddu of the Lord Venkateswara. So in this way, India has a very strong and comprehensive copyright law. So the Copyright Act of 1957. So violation of intellectual property can be called as infringement. So how, when somebody copies, somebody just without your approval, he's using your information or using your information for commercial purposes, etc. That is called infringement. So how to protect these your right using the law, available law. So these are the most important things which the experts will be presenting in a more detailed way. And so that all our students, scholars, scientists, researchers, and faculty will be able to understand what is this IPR, how we have to register a patent, how to get your right, the copyright or intellectual property right on a device that is invented, or on a model you have proposed, or something new you have invented that is not so far existing in this world. So intellectual property India is administered by the Office of the Controller General of Patents, Designs and Trademarks. So when we are talking about these things, we need to know something like we have a lot of research papers, publications, PhDs. But when you compare to these things, the number of patents being registered every year compared to other countries like China, we are far behind. So what is the reason? Whether we do not have awareness or our research is not patentable, or all those things, we need to take it seriously and we need to start patenting more aggressively. So whatever the inventions, whatever discoveries, whatever the models you propose, those things you need to patent. So that is maybe these kind of webinars will give us, the scientists, a vision and a know and awareness what is IPR is all about. Many times, many of the researchers I know, they do not mind in patenting. So they publish without thinking about patenting. So once it is published, I think it cannot be patented. So in this way, all these intricacies you should know. So these experts will be explaining us. Especially, we need to, being teachers, we need to inculcate the kind of inventive nature among the students. The students should be given that kind of knowledge, that kind of inputs, so that they should not like routinely study the subject. They need to think how best, how I think you can do something new, how you can be inventive, you have to be creative. So that kind of nature we need to inculcate among the students. That is the most important responsibility of the teacher. It is not simply presenting a lesson from a textbook, a lesson from a notes, a lesson from which is there for the last several years. So you need to tell the student, okay, this is the theory, this is the model. You should think, can you improve on this? Can you improve on a gadget? Can you improve on a program? Can you improve on a process? Can you improve and make a difference? And can you save money by improving a given process? Like that, the student should be given an opportunity to think differently, and so that that inventive nature and is given and inculcated among students. That is the most important. So then only the inventors will come. If you simply, okay, you study well, score first rank, then go, no, that is not correct. Being scientists, being engineers, we need to inculcate what is new you can do, you can think. Don't be thinking routinely. You think differently, try to improve a given process, try to improve existing device, try to devise and design a new product like that, whether it is a physics or chemistry or other sciences, we need to inculcate. And maybe the teachers should have these kind of webinars even among students time to time, so that these students will become the great inventors of this country. So again, I thank the organizers for devising such a wonderful webinar, which is useful for everybody, whether it is arts, humanities, science, engineering, because IPR, you can have a copyright. When you write a book, you can have a copyright. You design a trademark, you can have a copyright. You can protect the trademark. When you devise something new, you can patent it. So in this way, if it is a geographically important thing for a given area, you can also register that. So in this way, there are many types of IPR, intellectual property rights. So we do not know all these things fully well, but we have experts here because it is law. You have something you wanted to patent. So what is the process? What is the procedure? How much money we need to spend? How much time it will take? So whether we can, if it is rejected, can we appeal again? So what kind of procedures we need to follow, and how much time it will take, whether it is in India, how much time it will take, if it is in America, how much time it will take, how much money we need to spend. Suppose if it is in Australia, how much time it will take, how much money we need to spend. All those details will be given by experts. So if you are able to spend that kind of money, you can even patent at international level, so which is much faster and it is having more visibility. So your patent may be bought by a company, maybe you can become very rich and popular. So I wish this webinar a great success, and all the doubts of all the young inventors are clarified by the experts who are present here. Thank you very much for giving me this opportunity. I wish all success in this webinar and look forward for many more such webinars from these organizers. Thank you very much. Thank you.
Sushma, please unmute. Sushma, please unmute.
Thank you, sir. Thank you very much. We are very grateful for the time and effort you took to share with the webinar participants. Now, I would like to invite Dr. Rajalakshmi Madam, Assistant Professor, Department of Physics, to introduce one of our speakers, a senior professor, Professor T. Ramakrishna Garu. Madam.
Thank you, madam. A very good evening to you all. On the behalf of Department of Physics, Adikavi Nannaya University, Rajamahendravaram, I extend a warm welcome to our guest speaker, Professor T. Ramakrishna, Chair Professor, DPIIT Chair on IPR, Postgraduate and Doctorate Council, National Law School of India, NLSIU, Bangalore, for the event on intellectual property rights in academic and research. Let me share a few lines of his biography. His academic professional, visiting faculty, Professor of Law, present responsibilities of teaching for BA, LLB, and LLM. His present positions at NLSIU is Chair Professor, Head, Center for the Intellectual Property Rights and Advocacy, NLSIU, Chairman, Postgraduate Council, NLSIU, Bangalore, Resident Administrator, Microsoft Scholarship Program, Mumbai, India, Team Leader, Fact Screening and Transformation Process Project, Germany. His administrative experience: Vice Principal, Vidyavardhaka Law College, Mysore, Karnataka; Principal, Vidyavardhaka Law College, Mysore, Karnataka; Member of the Senate, University of Mysore; Member of the Syndicate, University of Mysore; Chairman of the Board of Examiners, Mysore University, Mysore; Member of the Board of Examiners, NSS Program Officer; Chief Warden of the Halls of Residence; Coordinator, Center for the Intellectual Property Rights, Research and Advocacy. His projects: Project on Globalization and the International Governance of Modern Biotechnology, IUCN Project, WHO, Government of India Project, Ministry of HRD, Traditional Knowledge Protection, Wipro, Bangalore, etc. He is a member of many professional bodies. Many conferences, web series, seminars are conducted by him. He is an editor-in-chief, March of the IP Law newsletter. It is a great pleasure to welcome you, sir, as our guest speaker. So on the behalf of one and all present here, let me extend a warm welcome to you, sir.
Thank you very much. Let me at the outset thank Honorable Vice Chancellor of Adikavi Nannaya University, a very well-known educationist and academician who has been trying to bring major reforms in this university, who has given an excellent start to this particular webinar program by identifying certain key factors. In my opinion, the key factors that the Vice Chancellor was trying to bring in is about the innovation culture amongst the researchers, translating the academic output into a commercially viable IPR. The mindset of the researchers and why India should be able to do much more than what China is doing. These are some of the points that which caught my attention. Let me just start off with that and then go to the patent and other issues. As we know, the number of scientific publications that we are referring to at the global level, India stands at the 3rd place next to China and USA. It moved from 5th place to 3rd place. And if so many publications are coming out in the field of science and engineering, why we have only 50,000 applications filed? And that too, among 50,000, nearly 70% are foreign applications. Only 30% of the applications are coming from Indian inventors. Where are all other research outputs going? That was his concern. And second one, when you are in the lab, when you're a researcher, are you merely an academic researcher? Or should you get yourself transformed into an academic inventor? And the transformation from academic researcher to academic inventor, I am sure, is going to lead you to become an academic entrepreneur in the form of spin-off and other things, where you will be able to further your invention, take it to the market, take it to the community. Not only you prosper, not only your university prospers, but also the economy is going to improve. So these are the very strong messages that I could get from Mr. Jagannath Rao. And therefore, let me at the outset thank Professor Jagannath Rao for having given that particular lead to this webinar. Honorable Vice Chancellor, sir, Sushma Priya, the principal of the college, the academic council members, and faculty and researchers. India has come a long way in acknowledging, accommodating, and developing the IP ecosystem in our country. If you just go back to pre-TRIPS era and the post-TRIPS era, pre-national IPR policy era and the post-national IPR policy era, you find tremendous progress has been done, and the present IP ecosystem has been acknowledged and applauded by most of the developed countries, despite the fact that they have certain concerns about some of the provisions which we consider to be very, very important from our side. For example, the grant of compulsory license, the invocation of Section 3D of the Patent Act. These are the concerns of these developed countries. Nevertheless, India has been able to move ahead. The 2016 WIPO report, I'll be coming to the presentation now in a short way. The 2016 WIPO report, it stated that the pendency of patent applications, the maximum is in Brazil with almost 96 months. And the next one is India with 84 months. But in 2018 and 2019, if you just look at how the disposal rate has increased in India, you'll be surprised. An application filed by the startups from the date of request for examination gets granted within a span of 300 days. And if that is the speed at which Indian Patent Office can function, what is the transformation that it has brought about? And the application for trademark, right, the waiting period is just a month, right, for the examination process to get over. So it has come down considerably. So from that perspective, if you look at the modernization of the patent office, has definitely been an excellent progress that has happened in our country. Well, friends, with these, I thought I would just quickly take you through the patent system and the public interest very briefly. Sushma, I will have around some 30 minutes time. Kindly inform me. Yeah. Well, before I proceed with public patents and public interest, let me just point out as what is the rationale, what is the evolution of the patent system, and what's the rationale behind that. Now, the question that comes up before us is it an incentive to invent? Is it an incentive to disclose? Or is it just a post-invention incentive? Or would you consider it merely from the perspective of a reward? Or is it a mechanism to promote competition? Like, if a major pharma company comes out with a particular drug for a particular disease, and if there are any side effects, the other company would compete and then come out with a better medicine. An information technology related company which has certain products related to the market, and the competitor would continue the research and then come out with a better technology. Is it leading to competition? These are all the issues that come up. All these could be in the form of rationale for the patent system. Go to the incentive to disclose. An individual who has an excellent idea, which is the outcome of his serious research for several years, would want to publish it. But you remember Jagannath Rao said, publication might be coming in the way of patenting. As Dr. Mashelkar said once, publish and perish. Why did he say that? He was saying that in the context of patents. And therefore, he modified that particular statement and said, patent, publish, and prosper. First go for patent. You're going to get the benefit of the patent. You can exploit the patent. Then publish, you'll get recognition. And then from both, you're going to earn and therefore prosper. So now, when I'm talking about this particular invention that you have with you, you may be eager to publish, or you may not be eager to disclose it to the world at all. Human mind works in such a way that an individual wants to keep that to himself as close as possible. Now the state pitches in and then says, will you please disclose that in the larger interest of the community? He may be hesitant. Then the state would offer him incentives and say, well, I am going to ensure that whatever you have invented can be enjoyed by you exclusively for a period of 20 years. And we are going to ensure you that nobody else would interfere in your right. We're also going to ensure you that if anyone interferes, we're going to have a remedy before the appropriate forums. You can commercially exploit that. So this might motivate him, and he says, yes, I'm going to disclose. He discloses, and after disclosure, after satisfying the conditions, he gets a patent. So we have created a monopoly in favor of that individual who invented. When I say monopoly to the exclusion of the entire community. Is it worth giving? The answer to that is, look at the larger public interest. That particular idea in the form of an invention has already been disclosed by him which comes into the public knowledge at the earliest point of time, which could be the starting point for a further invention in our country. As a consequence of which, that leads to promotion of the progress of science and useful arts. The community is benefited, at the same time the individual who innovates is also benefited. And therefore, friends, all these would constitute the rationale. And the law relating to patents has a very, very long history, going back to 1474 Act of Venice. And then the UK, they started granting latest patent in the form of monopolies to products which were brought into the country, which were new to the country. And they said that those who bring the new product to the country would have the monopoly over that. And that went to such an abysmal extent that they started misusing that. Then the parliament intervenes and then says, no more monopolies. And then Statute of Monopolies 1624 abolished monopolies. After abolition of monopolies, there was one particular provision in the Statute of Monopolies itself, which said that for a new invention, there shall be granted a right, an exclusive right for a period of 14 years. Why 14 years? The apprentice period is 7 years. A person to understand the technology, existing technology, will have to work for 7 years to become a skilled person in that. And if it's a new technology, an individual would require double the time. And during that period, let the inventor work that particular thing. So on the one hand, you are granting the monopoly. At the same time, you are ensuring that the community gets access to that particular technology and the knowledge. Once that period is over, it comes back into the public domain. That's the Statute of Monopolies. Similarly, US Constitution also provided within the Constitution framework itself the protection. And the first international development that happened was relating to giving priority to an applicant. If I file an application in one country today and file another application within 12 months in another country, my second application would be dated back to the first application, and therefore I get the priority from the first application date. That was the hallmark of Paris Convention. After that, series of conventions, series of treaties have come in. Almost 30 international conventions are in force relating to intellectual property rights. India started off with a patent law way back in 1856 itself and went through different changes in 59, 1883, 1888, 1911, and then 1970. After we signed TRIPS, which imposed minimum obligation on all member countries, right, we have made amendments, tries to our Indian Patent Act. That's briefly about the evolution of the patent system. Friends, if you just look at the statistics in India, right? See here, the patent in 2014 and 15 was around 42,000 by applications. It has increased by 8,000 in 2018-19, and it's increasing now. Design again from 9,000 to 12,000. But see the trademark application here, 2 lakh, now it's gone to 3,23,798. GI also has increased. Copyright, which was separately administered until 2016-17, which has moved into DIPP now, has also been progressing in that particular area. The one IPR which has not been utilized at all is semiconductor integrated layout design. This was passed to comply with the TRIPS obligations, and only 2 have been granted registration so far. Well, as far as trend in trademark applications are concerned, you find from 2 lakh to 3.23 lakh applications now. This is a trend that you find there. And anyone who looks at the Indian patent system will always be curious to know what was that particular patent that was granted in India, which is called as the first Indian patent. This is Alfred Dippening, who was a civil engineer and inventor in West Bengal, and he files the first application. You can just see, out of curiosity, the act comes into operation on February 28, 1856, and he files application on 3rd March 1856, within a span of 3 days. He was waiting for that particular act to come into force. And his invention was an efficient Pankha pulling machine. Right? This was the first to be filed under this act, and this is numbered as number 1 of 1856. Of course, he went on to file other applications and then got other patents here. The question that comes up at the outset is what would constitute an invention for which patent should be granted? Patents should be granted for invention, either product or processes. It cannot be granted for a discovery. Let me just point out, because I find most of the faculty from science community here. Anand Mohan Chakravarti and the Pseudomonas bacteria. Anand Mohan Chakravarti was asked to find a solution for oil spills. He found that this particular microorganism has plasmid which can degrade hydrocarbon in the oil. And then he started off with that particular experiment. Ultimately, he comes out with an organism which had 4 plasmids in it. Through genetic engineering, he created an organism with 4 plasmids. Sought patent for this particular invention. When it goes before the patent office rejects that on the ground that this is a living organism or it's a product of nature. Then the first appellate board, it said, well, this is a living organism and therefore should not be granted patent, but this is not a product of nature. It ultimately goes before the Supreme Court, friends. The Supreme Court examines the law of US and says, what will be patented in US is any invention which is either a manufacture or a composition of matter. Any composition of matter and any manufacture shall be eligible for patent. Is this a manufacture? And the court interpreted this to be a manufacture because there were different raw materials put together and the end product would work right as a new product altogether. It is also composition of matter. And when would such a patent be granted? The court says that as far as US is concerned, anything under the sun would get patent protection provided it is having human intervention and is markedly distinct from what is found in the nature. Friends, the reason why I have brought in this particular example is to immediately distinguish that from the invention from the discovery. Just have a quick look at what I have indicated here. In one of the cases, the Supreme Court of US said, Funk Brothers case especially, for patents cannot issue for the discovery of the phenomena of nature. The qualities of this bacteria, the bacteria here was Rhizobium bacterium. They claim protection for the culture of the Rhizobium bacteria. The court says, the qualities of this bacteria, like the heat of the sun, electricity, or the qualities of metals, are part of the storehouse of the knowledge of all men. They are manifestations of the laws of nature, free to all men and reserved exclusively for none. And the court observes, he who discovers a hitherto unknown phenomena of nature has no claim to a monopoly of which the law recognizes. So you can't claim invention or discovery for a patent. If there is an invention from such a discovery, it must come from the application of the law of nature to a new and useful end. That was the focus here. And what has been claimed in the by Anand Mohan Chakravarti, you find it indicated below. It says, his discovery is not nature's handiwork, but his own. Accordingly, it is patentable subject matter under section 101, and therefore they brought in the test of human intervention in this particular case. Well, friends, the law is such that you are going to get patent if you are the first inventor, as it was there in America previously. But now it is one who files the patent application first. If all of us are inventing on a particular product and all of us have come out with that particular product invention, but all of us will not get patent, and the first person who goes to the patent office on his own would get the patent because he is claiming first, he is disclosing first. See a very curious example that I'm giving here in what happened in US. Alexander Graham Bell, whom we know about, the inventor of telephone. And very few have heard about this man whose name is Elisha Gray. Did Elisha Gray also work on telephone? Did Graham Bell also work on telephone? The answer is yes. Why? Graham Bell got it first? Simple answer. On this particular day of 14th February 1856, Bell's lawyer entered the patent office first. He was the fifth person in the day. And Gray's lawyer entered the office later, around 39th in the day, same day. And patent has been granted to Graham Bell, who claimed it first. Number is 174465 is a number. However, the patent office later stage acknowledged Elisha Gray and also felicitated Elisha Gray at a later stage. But the patent went to Graham Bell. Well, that apart, how do you get a patent in a particular patent office? Very briefly, and then I'll go to other issues. You will have to file an application in the Indian Patent Office, and these are the steps that you're going to follow. Filing an application, you request for examination, then it goes for publication, and then the examination process starts. And after publication, before grant, there will be pre-grant opposition by any interested person, any person. After the grant, by any interested person, there will be post-grant opposition. So it's called as pre-grant and post-grant opposition. And then there will be registration and renewal fee payment. Just to quickly tell you, when you file an application, you're going to file an application either as a provisional application or a complete specification. Why do you file a provisional specification? Because you have not yet firmed up your invention. There are certain loose ends to be filled, certain more inventions, certain more experiments to be conducted. In such circumstances, you're going to file a provisional application, and then you will get 12 months time for filing the complete specification where you're going to make claims. Supposing you are a startup, supposing you're a small entity, supposing one of the applicant in your application is a women inventor or a government undertaking. In all these cases and few more, there is something called as expedited process of examination. You can request for an early publication, which means you need not wait till 18 months. You can request for examination immediately after the publication. So early examination and early publications you are requesting. And that goes into what is called as a Tatkal system. That was the point that I was making in my inaugural talk when I said that it was granted within the span of 300 days after the request for examination. So that expedited examination process is possible in India. And if you want to have patent protection or priority in as many as 153 countries, you can file what is popularly called as the PCT application or Patent Cooperation Treaty application, and through one application and one fees, you're going to get priority in 153 countries. You're not going to get patent. Be careful. You're going to get priority in all these countries, and any applicant who files subsequently in those jurisdictions will not be able to get patent as against you. And you will get 30 months time to enter into national phase and then get the patent in those specific jurisdictions. At the end of the day, patents are granted by the National Patent Office or the regional patent offices. And patent rights are territorial in nature, in the sense you're going to enjoy the patent only in that specific jurisdiction. If you get patent in India, you cannot enforce the patent in US or Russia. If you get patent in America, you can enforce the right only in US and not in other countries. That is, as far as patent process is concerned, very, very quickly. Well, friends, when you are inventing in your lab, and when you know that you have something which could be subject matter of patent, you will have to do a prior art search yourself if possible, or contact your IP cell in your organization and request for conducting this particular patent prior art search. And the prior art search, you're going to examine these aspects, especially the novelty and non-obviousness, and the patentable subject matter is one other aspect. So what are the requirements for patentability? We would say that it must be a patent eligible subject matter, it must have industrial applicability, it must be novel, it must be non-obvious, and it must have a written description. Well, friends, there are certain inventions which are capable of getting patents, and there are certain inventions which are excluded from patentability. Let me just move on to what is excluded from patentability. You should know as to what is not patent eligible. And Professor Jagannath Rao was pointing towards one or two of these. For example, if it's a frivolous invention, you say that a machine is a perpetual motion machine. A machine which gives output without any input, you're not going to get patent for that. Or if it's merely a discovery of a living thing or a non-living thing, you're not going to get patent for that. Similarly, if it's opposed to morality or public order, right, you will not get patent for something opposed to morality and public order. Like a machine which can kill thousands of people at a time, or a machine for gambling, or for any illegal purpose. So these are opposed to public order, would not get the protection. One thing I would like to point out at this particular stage is the fourth one that I am referring to here, right, in the form of new form of known substance. Their case before the Supreme Court of India, called as Novartis. Novartis was the Union of India, where Novartis had claimed patent for beta crystalline form of imatinib mesylate. Imatinib mesylate was known, imatinib was known, and they claimed patent protection for beta crystalline form of imatinib mesylate. The patent office refused. Supreme Court also upheld that particular refusal and said that what has been claimed here is a new form of a known substance. To claim patent protection for that, you are supposed to establish that the new form has an enhanced therapeutic efficacy. If you can show the enhanced therapeutic efficacy, you would get the patent. But what you have shown here is the enhanced clinical efficacy, and therefore you shall not be entitled for any patent. So this section 3D is one of the important provisions in the Patent Act, which is that inclusion of which is opposed by some of the developed countries. Similarly, an admixture, if you just mix two chemical substances without that having any synergistic effect, you're not going to get patent for that. Or if you arrange known devices, also you're not going to get patent. Any medical methods like prophylactic, surgical, diagnostic methods, they will all be excluded. Or any plants or animals, or any method of agriculture or horticulture is not patentable in India. When it comes to the field of technology, information technology, a computer program by itself or a business method by itself would not get the patent protection. Any literary work, etc., would not get protection, or the method of playing will not get protection. And the last part is traditional knowledge. I think this audience is aware of the issues relating to neem, turmeric, basmati, so on and so forth. In all those cases, India had to fight and then ultimately get those revoked, patent revoked. And now we have in India what's called as traditional knowledge digital library built up, which has been shared with these patent offices. And traditional digital library has information about all our Ayurveda, Siddha, Unani, Yoga information. The moment an application goes before any of these patent offices, patent office will also cross-verify with TKDL, and there are many instances of application being rejected or withdrawn in European Patent Office and other patent offices based on disclosure in the TKDL. Then friends, with this background, let me just come down and then tell you, in the context of COVID-19, right, are there provisions within the Patent Act which is going to balance the patentee's right with the public interest? There are quite a few. Number one is experimental use to which it can be put. And within section 47 itself, it very, very clearly says that the government has got the particular power of importing any patented product to be distributed through its hospitals and its dispensaries. And therefore, there is no need for obtaining permission from the patentee if the patentee is reluctant to distribute. Government use is also possible. And in case the person who is having the patent has not been providing it at an affordable price, has not been working the particular patent in India, or if the patentee is not meeting the reasonable requirements of the general public, Supposing we need 1 lakh tablet for a particular disease which is threatening the life, and if they're providing only 100 or 200 or 300, in such circumstances, there is something called as compulsory license to be granted. See, the government can ask any other pharma company which is capable of manufacturing it, who initiate this particular process, to go ahead and then manufacture that to meet the needs of the general public. And similarly, if there is an experiment to be conducted by a company so that the patented product can be released into the market after expiry of the patent period immediately, it can start conducting these experiments even during the subsistence of the patent period, and that will be exempted. That's popularly called as Bolar exception, called as use for regulatory approval. And similarly, since India follows international exhaustion, if with the permission of the patent, if it has been introduced into any other market where it is sold at a lesser price, then those products can be imported into India without violating the rights of the patent. Friends, the reason why I have just highlighted all this is just to tell you that there are exceptions and limitations which can be utilized in the larger public interest. Well, friends, pharma patents and public interest is something which I'm going to quickly comment on. See here, all the pharmaceutical companies have been following these strategies, offensive business strategies as well as defensive business strategies. Offensive business strategies are in the form of introduction of new formulation. They can create patent clusters or thickets, or they can aggressively enforce the patent rights, or many a times they may pay the generic manufacturers to not to enter into market in the form of reverse payments, or they themselves can come out with pseudo generics or authorized generics and thereby do an offensive strategy. Then there is also scope for defensive business strategies, which they do in the form of licensing and cross-licensing. I have a rich research portfolio. I just license out to others so that others are not going to do any research in that area and they would depend on my research. So license. Or if they have done some work, I'm going to license out mine and get license from the other one in the form of cross-licensing. Or I would enter into multiple collaborative research or follow the differential pricing mechanism. All these are defensive business strategies adopted by the pharma companies by utilization of the IPR system itself. And within the patent system, you have all these flexibilities in the public interest, to which I pointed out just a few minutes back. One is the research and early working exceptions, then data protection or data exclusivity, control through anti-competitive thing, and section 3D to which I was referring, which avoids evergreening of patents, compulsory licensing or parallel importation. Several examples are there, which I may not be touching now. Well, the patent policy will have to be subservient to the drug policy or the health policy. That should always be the case. And therefore, in this particular pandemic situation, patent rights can be regulated, or the patentees will have to make available the drug at an affordable price. Otherwise, there is universal healthcare and pricing policy mechanism to regulate it. Let me just touch upon artificial intelligence briefly, the challenges to the patent system at present. And you know what this particular AI is. I'm not going to go into what is the definition of artificial intelligence. I'm sure Professor Reddy is going to cover that. But the blockchain also is equally an intriguing one development that's happened. Starting from Satoshi, right, who started off with this, and the whole trend that you find and the key players that are there. The patent has been taken for different concepts around the blockchain technology, starting from verification, elements, smart contract, authentication, payment, consensus, digital currency, blockchain node, cryptocurrency, so on and so forth. Then, friends, these are the families by assign, patent families by assignees who are having control over the blockchain technology patents. And this has been utilized, and there are quite a few technologies which have been subject matter of patent and subject matter of utilization for a strong system. But the question that can come up in case of artificial intelligence is this: who would become an inventor in case of artificial intelligence? One particular issue that came was whether this particular AI machine in the form of Daubus could get the patent as an inventor or not was the question, and the US Patent Office and the European Patent Office refused to grant inventorship to the machine, the Daubus. So Daubus cannot be an inventor is one of the conclusion to which all these systems have come for various reasons which I have listed here. Then friends, United States has come out with this particular exclusion whenever the question of artificial intelligence getting patent in the form of computer implemented inventions. That's in the form of two-step tests they follow. They say whether the claims at issue are directed to a patent ineligible concept. If they are, then elements of all claims must be examined to determine whether they have any inventive concept sufficient to transform the claim abstract idea into patent eligible application. Then friends, United States Patent and Trademark Office has modified this particular test and says, to find out whether the claim is for an abstract idea, and if the answer is yes, then go to the second step and find out whether they have integrated that into practical application. If it's integrated into practical application, then they qualify for patent. And in India, we have Section 3K guidelines, which very clearly say that you look at the underlying substance of the invention rather than the form of the claim to give patent protection for a computer program or the artificial intelligence based computer program. Some of the examples, right? Well, friends, let me just touch upon one more aspect under the patent system. You have the patent. Since this particular institution is also science and technology, most of you know as to what these technical standards are. So technology standards are created by SSOs, standard setting organizations, standard setting bodies. And when technology standards are created, the technology which has become a standard might be subject of patent protected technology. If the patented protected technology, then the patentee will have a stronger position. Just see the whole situation. I have a technology, and my technology here, so it has become a standard. I have a patent over my technology. First, by having a patent over my technology, I get a monopoly, the legal monopoly I got. And along with my technology, there may be other 3 or 4 competing technology, but may not be the same technology. When my technology is selected and becomes a standard, then all other technologies will automatically get eliminated from the market. So first and foremost, I had the legal monopoly of the patent, and now I have the market monopoly of that becoming a standard. So I'm in a very stronger position. Am I likely to misuse or abuse my position? And if I'm likely to misuse my position, is there a law which tries to bring down the extent of abuse that I'm likely to commit? And therefore, is there any law relating to that? That is where, friends, this standards and patent issue, and especially the problems of standard essential patents would come into picture. Let me just point out just in 2 slides as to what has happened in India about the standard essential patent litigations in India. I'll just point out 2 aspects. One is who can decide whether there is abuse of dominant position by the SEP holder. Can Competition Commission have jurisdiction or not? The Delhi High Court held this Competition Commission as jurisdiction. Then let me just simplify whatever I have indicated here to tell you, supposing I have the cell phone, and the cell phone is sold at 50,000 rupees or 1 lakh rupees or 10,000 rupees, and the cell phone has a Wi-Fi chip, and the Wi-Fi chip here has in it the standard essential patent of X. Standard essential patent of X in the Wi-Fi chip. What would be the cost of that particular chip? The cost of the chip may be few hundred rupees, imagine. Let us assume 1,000 rupees. But the product is sold for 10,000 rupees or 50,000 rupees. Now, what should be the extent of royalty to be paid to the SEP holder on this particular chip technology? There are differences, different opinions have come forward. If you just look at the first part here, Competition Commission, they said that if you are focusing on the net sales price, that is 50,000, and then based on that percentage, if you say out of 50,000, you'll have to pay 2%. Then out of 1,000 rupees, you'll have to pay 2%. That makes a difference. So if it is for net sales price, that is discriminatory, it violates friend commitment, and it's anti-competitive is what Competition Commission said. Whereas Delhi High Court said, royalty calculation should be based on NSP only. It should be on the net sales price of the end product and not on the price of the chip. So this variation is happening in India, and that is to be fixed up. And the thumb rule could have been, you look at FRAND basis based on SSPPU, that is smallest saleable patented product unit, when the standard essential patent is part of the product and not a product itself. If it's part of the product, then apply SSPPU. If it's a product itself, then fine, you have no issues by applying net sales price. And this is the question where India stands now confused. And now, the consequences of cloud, which is covered in the FRAND, because FRAND is still vague. We don't have any guidelines to tell us as to what should be the FRAND commitment, etc. However, I just want to point out at this particular stage that there is something called as present value added method suggested by the European Commission, where you're going to look at the net present value calculation. It's not the present value calculation here. The reason is they emphasize on present value of potential future income that might be derived from SEP keeping future uncertainties. Current worth of the future income or future income discounted. And that is basis is the incremental value that SEP adds to product. What is its worth if not for those SEPs in it? Right? So it has deficiency. This is one of the suggestions that has been given. I think I have just started off with what a patent is and what is excluded and included, what is the procedure, a very simple level. And then I have come down to two issues. One issue is related to pharmaceutical substances, the other one relating to artificial intelligence, the third relating to standards. The reason, friends, why I just highlighted the last three is to give you a sense of the current challenges to the patent system that are happening, not just within the framework of patent itself, that what to get patent for, what not to get patent for, etc. How this particular patent system is going to operate in the society, in the market. So for that purpose, I've given you these three as just illustrative instances. Coming back to how academics will have to look at the whole process of patenting, etc. I'll not take up trade law framework because I think Sushma Priya has given me around 35 minutes. It's done. I'll just stop here. But before I stop, I just have some 2-3 comments to make or 2-3 remarks to make. As I was telling you initially, in an organization or in a university, there is a need for having an exclusive intellectual property cell, which shall take care of the innovation that are happening in each of the department by conducting what is popularly called as IP audit. I would suggest that this university will have such a cell, maybe starting from the Department of Physics itself, and then that particular team shall get expertise in doing a prior art search. When I say prior art search, it gets into a particular department, meets the faculty members, meets the students who are working on a particular project, tries to identify whether there is already a concept which can be developed into a a patentable subject matter, and are they working in the direction? So they start the iteration, and then moderation process they're going to start. And once they start the particular process, they will be leading them towards coming out with patentable invention at the end of their research. And they're going to capture that. And at the appropriate time, they're going to go ahead with filing of a provisional application in the patent office. And similarly, the IP cell is also going to look at all the scientific publications that are coming out from the organization. And those scientific publications that come out of the organization from the individual scholars will have to go to this particular IP cell to find out whether that has an inbuilt patentable subject matter within it. And therefore, without identifying that, whether it should be published or not. And these two ways you're going to capture that. Similarly, you're also going to capture all the other works that are worth protecting through copyright or through designs, and a spin-off which you start off with a trademark, or a startup from your organization start with a trademark and design, etc., etc. So the IP cell becomes a very, very important nodal thing. And the central government, through Department of Science and Technology, has introduced in every state the Council for Science and Technology, which has within itself the PIC, Patent Information Center. And the Patent Information Center's responsibility is to set up these IP cells and also capture the inventions that are there. And if they are institution-based inventions, the DST is going to take responsibility of getting that, getting the patent filed in a patent office. So the process would be done by them. I think you should encash upon these facilities that are already there. And I would want to see that this Adikavi Nannaya University researchers are going to keep this particular aspect in mind and utilize their expertise, their research outputs in converting that particular research outputs into a commercially viable, patentable product. I wish you all the best. Thank you very much.
Thank you, sir. Thank you very much. It was an outstanding content related to patents, especially its rational evolution. Different types of patents and making policies on patents and how to go for patents on different issues. So really, we are very happy about all the issues which you covered in this session, sir. Even though the time is less, but your great insights gave us a great knowledge. If you have any doubts, you can post on chat box or raise the hand option. Dear participants, if you have any doubts, you can post on chat box or raise the hand. Sir, can we have a 5 minutes interactive session, sir?
Yeah, please. I have no problem. I can wait. See, there are 3 speakers and you have told me clearly.
Yes, sir.
Time constraints, and therefore I just confined myself, restricted myself.
Yes.
I think you can go ahead with the next presentation.
Okay, sir. They will send the mail to you, sir. Sir, Pardasarathi Garu has asked some questions.
Yes, Pardasarathi Garu. I did not start off with this one. Okay. The patent is granted for the inventions. Right? I had told you about inventions. Whereas copyright is granted for expressions. Copyright would not be given for ideas. See, all those in the form of literary works, artistic work, the music, sound recording, cinematography. See, the books that you write is an expression. The dance an individual is going to perform is an expression. The drawing that an individual is going to make is an expression. Copyright protects all these expressions and not the ideas. Whereas an invention would fall within the category of the patentable inventions. Hope I have answered that question very briefly. Yeah.
Any questions from the participants?
Yes, madam, we can just proceed with the GB Reddy sir, and then at the end you may have.
Okay, sir. Thank you, sir. Thank you very much, sir. We are very grateful for the time and from your busy schedule to share with the webinar participants. Thank you, sir. Thank you very much. Now, I would like to invite Mr. N.S. Subbarao Garu, Assistant Professor, Department of Physics, to introduce one of our speaker, Professor G.B. Reddy Garu. Subbarao, sir.
Ma'am, it's okay. I can continue. The introduction can take place
No, sir.
subsequently. No, it's okay. I'll be coming back for the next of your series
Sir, I
also.
invite Mr. Y. Manos Deva, Assistant Professor, Department of Management Studies, will introduce our speaker, Professor G.B. Reddy Garu.
Department of Commerce and Management Studies. So, profile about Dr. G.B. Reddy Garu. G.B. Reddy is a lawyer turned academician, studied LLB, LLM, Constitutional Law at Usmania University, and PG Diploma in Human Rights from University of Hyderabad. Obtained PhD in Law from Usmania University in 1999 on the topic Supreme Court and judicial activism, its constitution in specific areas of constitutional law after 1980. His area of specialization is a constitutional law in LLM and judicial activism in PhD. He specialized in area of intellectual property right as an independent researcher, published as teacher. He is a brilliant academic record with 3 gold medals in LLB and 1 gold medal in LLM, apart from being the first candidate to have qualified for UGC JRF in law from University of Usmania University in 1993. He participated in High Court of he practiced in High Court of Andhra Pradesh for about 7 years before joining the Faculty of Law, Usmania University. He authored 20 well-revised books on law, including women and law and intellectual property rights law and copyrights law in India, and so on. He had been reviewed favorably in book review section of Hindu by Justice V.R. Krishna Iyer. He also published 56 articles on law published in standard national and international journals. He has been contributor on environmental law to annual survey of Indian law published by Indian Law Institute since 2013. He worked as a principal, University of Law, and head of the Department of Law, Usmania University, Hyderabad, from April 2005 to May 2008. During the period, he contributed to the university to introduce LLB 5 years integrated course at University College of Law and PG College of Law, Usmania University. LLM IPR and LLM ADR and LLM ITEL and PG Diploma in Cyber Laws. He has been a visiting faculty at several reputed institutions, including AP Judicial Academy, AP Excise Academy, CCRT, AP Police Academy, National Police Academy, Nalsar University of Law, and ICADR, and National academic staff colleges of Usmania University, Acharya Nagarjuna University, Bangalore University, VIT University, IIT Kanpur, and University of Hyderabad. As a part, he is director, University Foreign Relations Office, Usmania University. He was the founder director of legal cell of uh, Usman of University and worked in the capacity from March 2015 and August 2016. He was appointed as a member of General Council of Nalsar University of Law, Hyderabad, for the period between 2011 to 2014. AP State Consumer Protection Council, 2010 to 2013, and Hyderabad District Legal Services Authority by Government of AP. He is a life member of Indian Law Institute and the Institute of Constitutional and Parliamentary Studies, New Delhi, and Academic Studies Research Center, Hyderabad. He participated in several national and international seminars, workshops, conferences on law, allied subjects, present papers in Japan, Malaysia, Hong Kong, Singapore, and South Korea. He is a non-official visitor to Charlapalli Central Jail member, Charlapalli Central Jail, a member state, Telangana State Legal Services Authority, Chairman and Ethics Committee of CDFCFD, Hyderabad, and a member and Academic Council of Nalsar University. He is also a chairperson of Board of Studies in Law, Osmania University at present. Thank you, sir. Thank you joining this session, sir.
Thank you. Okay. Very good afternoon. Probably good evening. That is the proper term to all the learned faculty members and participants. Professor Jagannath Rao Garu, Dr. Ramaneshwari ma'am, Dr. Sushma Priya, and the other faculty members from the University College of Science and Technology, Adikavi Nana University, and Professor T. Ramakrishna Garu, my senior colleague and one of the most well-known authorities in the field of intellectual property rights in India and abroad, and Mr. G.R. Raghavendra, a good friend. Well, a wonderful tone has been set by the Honorable Vice Chancellor this evening when he explained about the importance of intellectual property to the academic institutions. And it has been continued by Professor T.R.K., who mostly focused on the patents, protection of inventions. In fact, when I was contacted regarding this webinar, I was entertaining an idea as to the continuation of such exercises by almost all the educational institutions of higher learning, because the topic is very wide, the importance is too significant, and the time is too short to cover everything in one session or one webinar. So this is the curtain raiser. And as far as the intellectual property rights are concerned, certainly the concept has been very correctly explained by the Honorable Vice Chancellor. But to add to what the professor said, I have a small presentation to make, and I would like to, in fact, make a very brief presentation. I'm trying to share my, screen with you. I don't know where to share. Yeah, I'm sharing it, and probably we will be in a better position to understand some of these aspects. Well, my topic today would be copyright protection, but before that, I think it is my bounden duty to touch upon some of the basic issues relating to intellectual property rights. Kindly look at the three wonderful statements which are on your screen. The economic significance of the intellectual property rights or intellectual property has been highlighted by an economist way back in 1997, when Bill Gates became the wealthiest man in the world. Then an article appeared in Harvard Business Review where the author, Lester C. Thurow, categorically mentioned that till recently the world's wealthiest human beings were oil workers, and today he is a knowledge worker. Bill Gates became the richest man in the world because of the intellectual property, because of the intellectual property in the form of patents or copyright in information technology, so on and so forth. Before that, it was Sultan of Brunei or someone else. They became very wealthy, not because of their intellectual contribution alone, but because of the oil, which is a material property. But here comes intellectual property, which was successfully, in fact, commercially exploited by a very intelligent person called Bill Gates. And today, the rest is history. Another important aspect is that in order to create intellectual property, one needs imagination, not only knowledge. Every knowledge may not result in creation of intellectual property. Therefore, to quote Albert Einstein, imagination is more important than knowledge. Sometimes imagination is the one which leads to the knowledge. Then I would like to draw your attention to another very important statement made in our National Intellectual Property Policy 2016. And just one or two sentences which are on your screen. We are looking at an India where creativity and innovation are stimulated by intellectual property for the benefit of all, not only for the purpose of creating wealth, but to benefit one and all. In India, where intellectual property promotes advancement in science and technology. But you also look at arts and culture, traditional knowledge, biodiversity resources, and where the knowledge is the main driver of development. And knowledge owned is knowledge transformed into knowledge shared. Please try to understand. Knowledge owned is transformed into knowledge shared. Knowledge sharing is very important because, uh, Spartaya Vardate Vidya, as you go on, in fact, discussing, as you go on deliberating issues, certainly the knowledge, the Vidya will be increasing. Same is the case with the education. The more it is shared, the more it is grown. Same is the case with intellectual property. And I would like to draw your attention to Prime Minister Narendra Modi ji's slogan recently in January 2020 on the portals of Indian Science Congress. He said, innovate, patent, produce and prosper. Certainly, this is going to be the thing of the future. And let me tell you that some of the leading universities like Adikavi, of course, Nanaya University is an upcoming and very promising university. But look at the world's leading institutions like Harvard University, Columbia University, Oxford. Every day we are hearing the name of Oxford, not because of only academic excellence, but because of the vaccine. We want such a thing to happen in the Indian universities also. So Oxford University and AstraZeneca came together. Ultimately, they are trying to do something, but it is an academic institution, is it not? Every university is capable of creating such or making such wonderful inventions. And that is a probably intention of Prime Minister Modi ji and many others. Well, another important aspect is that when we are dealing with, the knowledge workers, I mentioned that knowledge workers are the, wealthiest today. Look at four of them. First one is a course. Kindly understand, there is intellectual property in it. If you are a Michael Jackson fan, so you can enjoy it, no issue. But he was leaning, ahead by 45 degrees. Still, he was not falling down. You know why? Because the shoes which were used by Michael Jackson and his troop members, the technology used in the shoes was patented. You just Google, you will find out. The patent lapsed subsequently. So don't worry about the dance, but the technology, because the equilibrium is maintained there. Look at Harry Potter series creator. Second one, J.K. Rowling. Today she is the wealthiest woman in the world, author in the world. The wealthiest author in the world. How she became the wealthiest author? Because of copyright, again, which is an intellectual property. Because of the royalty she gets on the sale of her books throughout the world, on the production of the movies based on her themes. Of course, look at Bill Gates. 1997 statement was applicable to him. It is still applicable. He may not be the richest man today, but he is always in the top 10 or so, always, for the last so many years, 23, 24 years. And look at that mouse. There is something very peculiar about it. It is called Harvard Onco mouse. Harvard scientists came out with this laboratory created mouse under laboratory conditions. It was asexually reproduced only under the laboratory conditions. And this is patented in the United States way back in 1988 for use in cancer research. There is an intellectual, this is the result of intellectual property, not the intellectual property itself, right? So this is the importance of intellectual property in growing in modern times. And I think no university can afford to, lag behind in this endeavor. Then this brings me to third important point, because everyone has been talking about intellectual property. Maybe some basics have to be refreshed. We are looking at a property, not like the car, building and all, but property which is not visible to us, intangible property. Intellectual property is an intangible property. Second important aspect is that it is created by human brain, human mind, not by hand. When we labor, when we work hard by using our brain, then intellectual property is created. Third point is intellectual property is in the form of rights. Professor Ramakrishna was speaking about the patents. Patents are rights, trademarks are rights, designs are rights. Vice Chancellor said something about Tirupati Laddu. That is a GI. That is also right, collective right. Copyright is a right. Ultimately, intellectual property is in the form of rights, not something material. It encompasses all kinds of technology. Maybe blockchain technology, artificial intelligence, nanotechnology, chemical, information, bio, whatnot. And intellectual property cannot be confined to any particular area. You make an invention in your physics department, Adhikavi Nana University, get a patent for it. There is every possibility of somebody infringing your patent rights somewhere in Timbuktu. Because your intellectual property is mostly in the form of information. It is technological information which is protected for certain period. And that travels very fast across the national borders. It is transnational in character because it cannot be kept in a safe deposit locker. And last one is it confers limited monopoly rights. Intellectual property confers limited monopoly rights. In the sense, if you are the owner of your building, you can own it for 1,000 years. Nobody will say anything. But when you are the owner of a patent, you are a patentee, you can enjoy the patent rights only for 20 years. You can enjoy the copyright only during lifetime of the author plus 60 years after his death. If it is a trademark, every 10 years, if it is registered, must be, renewed. So there is a limited monopoly, limited period during which the monopoly, the exclusive rights can be enjoyed by either the creators or owners of intellectual property. And these are the main forms of intellectual property: patents, copyright, trademarks, designs, trade secrets. You can add traditional knowledge. You can add layout and integrated circuit designs. You can add, in fact, the biotechnology related inventions. There are so many, but these are the main forms. GIs are also to be added, geographical indications of goods. I mentioned about different kinds of intellectual property. So IPRs are not to be understood as if they are only patents or copyright. Absolutely not. If you look at their classification, you will find that there is something called industrial property. So industrial property is related to industrial revolution, industrial activity. You're talking about a property which can be produced in the industry, which can be used in the industry. This encompasses four things: patents, trademarks, industrial designs, geographical indications of goods. Then you have literary property. It has got nothing to do with industrial production and all. It is mostly, for the purpose of protecting the expression of ideas. That is copyright, the neighboring rights. For example, a cinema actor can claim his performance right as an actor. A singer who is making a live, recital is somebody who is called performer. If you are a teacher, you are a performer when you are delivering a lecture in the classroom or elsewhere. Similarly, the organizations like the radio channels, TV channels, cable TV, all of them have a right known as broadcast reproduction right. Then there are new forms of intellectual property. Plant varieties protection, new plant varieties, farmers varieties can be, you know, of crops can be protected. That is intellectual property. Life forms protection. Professor Ramakrishna mentioned about the, Pseudomonas bacterium, Pseudomonas aeruginosa, where, the Indian born scientist Anand Chakrabarti, working for GE, got a patent for this life form, which was created because of genetic engineering or genetic modification. Genetic resources and traditional knowledge. Don't think that intellectual property is coming from somewhere. In fact, it is found in our day-to-day life, whether it is the use of neem, use of turmeric, use of, tulsi, pudina, genetic resources. All of them are genetic resources. All of them can be protected as traditional knowledge. Then we have business methods, layout designs, computer programs, so on and so forth. This is the classification I have already mentioned. Now I'll come to copyright. This is important because about the patents, Professor TRK explained very lucidly. I must say something about copyright. Maybe, you ask any student what is copyright. If he is a naughty student, he will say right to copy. Copyright need not be right to copy. Copyright is a kind of intellectual property which is related to literary field, literary property. So literary property means it could be anything like, literary work, artistic work, musical work, dramatic work, computer program, photograph, cinema, whatever. But copyright is protected in case of expression of an idea. Expression of an idea. This is important. Every person will have number of ideas. If the idea is converted into an invention, like a product or process which satisfies the conditions like novelty, utility, that is usefulness, and non-obviousness or inventive step, you can get a patent for it. If that idea is converted into some kind of book, it is published as a book, as a, in fact, some kind of compilation, or if it is in the form of an artistic work, or in the form of some musical work, dramatic work, then that is protected under copyright law. You can ask me, because most of us are from science, few science departments, what relevance copyright has with us or with our activities. Certainly there is lot of relevance. Why? Because day in and day out, by, in fact, by publishing, by coming out with books, papers, articles, monographs, and many other things, we are creating intellectual property. Your PhD thesis is a literary work. Your monograph is a literary work. Your examination question paper, which is, prepared originally, is a kind of intellectual property that is in the form of literary work, right? Criticism, commentary, what not. All of them are databases, compilations, the information which we collect from different sources, either for the purpose of research, teaching, whatever it is. That is also intellectual property, literary work. Therefore, when we are conducting our research activities, or when we are publishing our own papers, our own books, monographs, research articles, right? When we are trying to quote others, we are trying to, in fact, summarize others' work, when we are trying to, in fact, paraphrase others' wordings, we must be careful about copyright. Because if you are writing something on your own, if your expression is original, then it will be copyright. You need not publish it, please. The moment it comes into this world, that is copyrightable. So copyright is a kind of literary property. First point, it protects not the ideas, but expression of the idea. It protects the expression of an idea. And once you express your idea, your expression must be original. Idea need not be original. If ideas are to be original, so many PhD theses wouldn't have been produced by now. Or so much, duplication wouldn't have been witnessed. What I'm trying to say is that same idea can be expressed in different manners. Ramayana, I think, I don't know how many versions of Ramayana are in circulation today, right from Valmiki Ramayana, Tulsi Ramayana, Kamba Ramayana, what not. You talk about, Ranganayakamba Ramayana or Veerappa Moili Ramayana. Everything is Ramayana. In fact, the plot, the characterization, everything is same. Expression is different. The way one expresses the plotting of Ramayana and others. So copyright protects expression of an idea. Suppose you are asked to draw the picture of an elephant. If you give the same assignment to 10 students, I'm very sure that 10 different kinds of elephants come into existence on the paper. Each one will be entitled to copyright as an artistic work in respect of that art of elephant. Another point you must understand is that copyright is a bundle of rights, not a single right. Many people think that copyright means only one. It's a bundle of rights. Many rights come into existence when you have copyright in a particular work. Like, you have the right to reproduce the same. If you are the author of a book, you can print any number of books. Your publisher can print any number of books. Original will remain the same, but many other copies can be produced. To issue copies, to perform the work in public, to translate the work, to adopt the work, so on and so forth. So copyright is not a single work, but bundle of rights. That is one. Then registration of copyright is not compulsory because the patents must be registered. Copyright need not be registered. You can simply say all the rights reserved. You can simply put C in a circle, means copyright reserved. Or if you are so particular, you can go for even registration of copyright now, which is under the Ministry of Industry and Commerce. Copyright registry also has come under single umbrella now, except one or two. And copyright is one of those intellectual property rights which has the longest lifetime of the author plus 60 years after the death of the author. Gitanjali of Rabindranath Tagore, that was, written maybe in 1920s or so. It got Nobel Prize also. Rabindranath Tagore died sometime in 1939 or 40, a little, 1 or 2 years here and there. Then his copyright extended till 60 years after his death. Actually, it was 50 years. So in 91 or 92, the Bengali, in fact, personalities, eminent personalities said, Gurudev Rabindranath is a great person. His copyrighted works should not come into public domain so early. So extend the term of the copyright. The then central government also obliged. Previously, it was lifetime of the author plus 50 years. It was extended to lifetime of the author plus 60 years. If there is an author, if there is no author, it may be only 60 years. Another point you must understand is that today copyright is not concerned only with the academic institutions or lonely starving authors, but it's concerned with many top-notch industries. Computer programs, you are talking about software programs. It is copyrighted as a literary work, right? In the entertainment industry, copyright is one of the important tools to protect the original works. Same is the case with media. Same is the case with publishing, cinema industry, music industry. Everywhere, copyright is one of the most important aspects. Then, what is protected under the copyright law? Copyright can be protected in case of works. What are works? Works normally, those works like literary work, dramatic work, etc., which come into existence, which are created. Suppose, a manuscript is written. Manuscript is written. There is a copyright in it. It need not be printed in order to get a copyright. So these are the works in which copyright can be claimed. You can see literary work, dramatic work, musical work, artistic works, like paintings, sculptures, etc. Sound recordings, which you may call phonograms, films or cinematograph films, photographs. One can claim copyright in a photograph also, if it is unique, if the expression is original. Then same is the case with broadcast and cable TV programs. This is another important aspect. Then you are talking about literary works. This is important to us because all the academic community, students, researchers, scholars, faculty members, we are more concerned with the literary works. I already mentioned the reason why we should respect the copyright in teaching, in researching, in publishing, so on and so forth. UGC also has come out with certain guidelines. You may remember in 2018 on academic honesty and integrity, there are guidelines relating to plagiarism and all. There is a connection between copyright protection and plagiarism also, anti-plagiarism measures. But as far as literary works are concerned, these are the rights which can be claimed. I already mentioned about it. I need not go further depending on this. Who is the owner of copyright? One question you just, you can recollect. Suppose, you submitted a thesis to Adi Kavi Nannaya University. That was sent for evaluation. Ultimately, PhD is awarded. Tomorrow you want to publish it. Who will have the copyright in it? The general rule is that whoever creates, he is the author of that work. Author means creator in the copyright parlance. So, if you are the original researcher, you are the author. In Hyderabad Central University, I was a member of a committee. There was an issue relating to copyright infringement. Then the PhD supervisor, the guide, he was saying, without my contribution, how can the thesis come out? So along with the student, I am also the author. I said, sir, legally you are wrong. Copyright Act of 1957 categorically says that author shall be the first owner of copyright. So the scholar is the first owner. You are only a guide. You are not writing. He is the one who is writing. You are giving inputs, right? Similarly, if the university has a policy which says that without permission of the university, the PhD for which the university has awarded the doctorate shall not be published, we must obtain permission. Otherwise, if the university has no such policy, certainly the concerned author or the scholar can come out with a publication. This is one, right? But copyright can be assigned. It's quite common, I think. As the faculty members and academicians, whenever you send an article for publication, then whenever it is accepted, then they send you a form, right? Assignment form, assignment of copyright form, right? And that's what we do. You recently, in fact, I sent one such, form to Cambridge Publishing, Cambridge Scholarly Publication, and something else. Then immediately they came out with a form. They said you fill it up and then send it back. That is assignment. Means we are assigning the copyright in that particular work to be published by the journal, book, publisher, or whoever it is. That is one important aspect. So assignment also is equally important. That's what I'm trying to say. Suppose you write a book as an author. Then you give assignment also, but no term of assignment is mentioned. Assume for a moment. Then it is presumed that it is only for 5 years. After 5 years, you can assign it to someone else. Similarly, if you are, in fact, assigning copyright to somebody, some publisher, but without mentioning the area where it is to be published, then the understanding is that it is only within India. Outside India, you can give it to someone else. These are some basic things which we have to remember when we go for copyright assignment. And it is quite common nowadays. to include all these aspects, including the royalty. Very unfortunately, the academic community doesn't get any royalty. In fact, they pay in order to get them published. Is it not? In order to publish a PhD thesis, in order to publish an article, there are paid journals. Very unfortunately, predatory journals who charge 1 rupee per one word, right? Or you pay 2,000 in lump sum, we will publish. But they are all cheap, honestly speaking. You have to publish only in the Scopus reviewed journals or UGC CARE journals. There is a particular list. I think you know that better. I need not mention much. About the management of copyright, etc., I will not discuss much. But when you are talking about the authors, authors have two kinds of rights. Please try to understand. One right is known as economic rights. Economic rights are, for example, you are allowing somebody to reproduce your work, your book and all, to print copies. Certainly, you have a right to receive the incentive in the form of royalty or lump sum amount. Same thing can be said in the case of issuing the public. A cinema producer, he is releasing the movie and he is expecting some economic incentive in return. So all of them are economic rights: right to issue copies, reproduce the work, right to communicate to the public, right to make a movie, sound recording, translation, adaptation, etc. Another point also you must understand. Suppose as an author, a person writes something, produces an artistic work, cinematograph work, whatever it is. And if A transfers, assigns copyright to B, and that is, for a paltry amount. Suppose B, when it becomes so popular, he transfers copyright to C. A can claim a share not exceeding 10% if the resale share price is 10,000 rupees and more. If it is more than 10,000 rupees, he can say 1,000 rupees are mine because you are reselling my product. So this is also another very important, very interesting right. And there are some moral rights also, because normally even after assigning the copyright, it may so happen that the assignee to whom we make the assignment, assignee may try to meddle with it. He may try to, in fact, distort it. He may try to claim that he is the author. But the right to be recognized as the author is vested only with the original author. He cannot say, suppose you are giving it to Cavendish Publishers. Cavendish Publishers cannot change the name of the author. You are the author, even if you assign copyright in it. So right to claim authorship of the work, you call it paternity right. Second one is integrity right. That is right against any damage to the reputation. Just because copyright is given, it doesn't mean that you can change anything and everything. Because it may so happen that you have a particular reputation. You have every right, something called integrity right, because suppose you are writing a beautiful article. The last 2 or 3 paragraphs are very important. Only when those 3 paragraphs are printed, your article or paper becomes more meaningful. Suppose the publisher removes only those 3 paragraphs. People will think that you don't have the, in fact, scholarship in the particular article. Your reputation has come down. That is the reason why every author has a right known as the integrity right. That is right to restrain, right to prevent any damage in case of modification, mutilation, distortion, revision, so on and so forth. This is another important point. And apart from this, there are other rights. For example, you are producing your video lessons, which are telecast through, let us say, AP Open University or some other university, some other education channel like EduSat, Nipuna, this and that. Certainly, you are the owner of copyright, but apart from that, you are also having some rights known as related rights or neighboring rights, especially as the performer, because when you deliver a lecture in the classroom, you are a performer. Don't think that late Shobha Naidu was the performer, MS Subbulakshmi was the performer. They also were great performers. But as teachers, all of us are also performers because we perform live. Right now I am performing, please. So we have a right. Without our permission, no recording can be made, no telecast can be made, no broadcast can be made, no further, re-recording can be made. It is essential. Same is the case with the teachers. Please try to understand. If anyone tries to record your conversation and all, especially in the classroom, you can always say, no, don't record. I'm not giving permission. You understand? Because they are paid only to teach, not to perform and, record our lessons. This is something known as related rights. If you are a performer, if you have a unique style of performance, you can protect it for 50 years. If suppose a cinema, take for instance, I'll give a very lively example. Time is 6:05 in my watch. I know that the more it grows, the interest also comes down. So I'll keep it sweet and short for another 5 minutes. Sushma ma'am, is it okay? 5 minutes, please. Not beyond that. Anyway, I think
Sure,
now
sure.
point is very simple. Yeah, I'll close within 5 minutes. Uh, I'm talking about broadcast reproduction right. See, even in case of cinema also, copyright is for 60 years from the date of its release and all. Now the question is, you come across ETV, for example, ETV channel, Gemini TV, Ma TV, any other channel, telecasting the same movie again and again every 2 or 3 days. You must have seen that. They acquire copyright in that for a time period. But along with that, they acquire something called broadcast reproduction right. This is important. That means for 25 years from the date of acquiring this right, any TV channel, any radio channel, any educational satellite channel, whatever, they can broadcast or telecast such movie, such program any number of times for 25 years. Today morning they can telecast, afternoon they can telecast, and this applies even to educational programs also. This is another important point. So this is broadcast reproduction right, I have already mentioned. Performer also is a teacher. Please try to understand. We are clubbed with many others, actors, singers, musicians, dancers, acrobats, jugglers, conjurers, snake charmer, a person delivering a lecture. So if you are a person delivering a lecture, you are also a performer and your performance will be protected for 50 years. That's another important point. Now, in fact, we are coming to another important aspect, infringement of copyright. I said that as teachers, as scholars, we are supposed to respect the copyright of others. So without any permission, without any license, if we reproduce their work, because wholesale copying is quite common in academic circles, you must understand. But there are a number of tools which have come into existence, like Turnitin software, anti-plagiarism software. Within seconds, once we upload any data onto this particular website, within minutes it will find out from where how much data is taken, what are the sources. If it is a pirated work, if it is full of copyright infringement, right, then you will come across a colorful screen. So red color, blue color, gray color, whatever it is, and against each color there will be a source. So they will say how much percentage is taken, 18%, 20%, 5%. What I'm trying to say is that academicians also must be equally careful while dealing with copyrighted works. We can quote. We have to quote a little, maybe few sentences. You can't quote one entire page. And when we quote, we must acknowledge the source also. Even if, but you can't say that, I will quote 5 pages and acknowledge. That is not permitted. We have to quote a little and that too with due acknowledgement. This is important. And there are other issues as well. Nowadays, piracy is taking place. Piracy is different, please. Please try to understand. In the context of copyright, we have something called piracy. We have something called plagiarism. We have something called infringement. So piracy is theft. So suppose I sell a pirated CD as if it is original CD. That is piracy, wholesale theft, almost. Right? Infringement is doing something which is not authorized. like, copying bigger portions, higher portions, and not for fair use purpose. Fair use means it may be for academic research and other purposes, only for teaching, non-commercial purpose, right? This is one. Then we have plagiarism. What is plagiarism also, I need not discuss, but you must understand that under the copyright law, these are some of the exceptions. If somebody says that you are infringing my copyright in the work, then you can say that I used it only for the purpose of research or private study. I used it only for criticism or review. I used it only for reporting of current events, something like that. So there are about 30, more than 30 such exceptions under Section 52 of the Copyright Act. And in 2012, a very important amendment was brought in India to make changes to the copyright protection. And today, in fact, if you have the copyright, that includes even right to store works in any medium by electronic or other means. If I have copyright in this PPT, I can store it in any medium by electronic means or other means. So right to electronic storage also is part of the copyright. You must understand that. Then in case of future technologies, for example, only copyright in the form of, let us say, CD is assigned. In future, if some other technology comes, there is a need of further assignment. This can't be sufficient. The old assignment will not work. There are a number of other provisions. Today, copyrighted works can be used for the benefit of persons with disabilities, especially visually impaired persons also. And if a person has copyright but he is not publishing any rare manuscript, etc., then one can ask even for compulsory license. Much against his wish, now it is the registrar of copyright who can issue such license. So there are many such changes which have been brought into existence in the year 2012. I know that this is not a full-fledged class, therefore I am not discussing many. I will discuss. Then copyright infringement and plagiarism. This is important. Plagiarism means to kidnap. We are kidnapping others' work, others' literary work, others' article, others' book. Then it becomes plagiarism. You can call it appropriation or imitation of the language, ideas, thoughts of another author and representing them as if they are our original work. That is called plagiarism. I think every PhD thesis is uploaded on Shodhganga website. You are aware of it. So Shodhganga purpose, there were memorandum of understanding signed between the universities and InflibNet, thanks to UGC. Now, in fact, 3 months we have to wait after uploading on Shodhganga. Then only we can go for publication or presentation, etc. Then there are different types of plagiarism. Some people plagiarize everything and they just give their name by replacing the other's name. Some people copy and paste. Computers made it very easy now. Some people go for word switch. Instead of looking, they may see whatever. And some people publish their own articles any number of times. But that is also plagiarism, self-plagiarism. And people may indulge in plagiarism either deliberately or accidentally, intentionally. Reasons are many. People are lazy. Most of them, not all of them. Because they don't want to work. Ready-made thesis is much better. Some people don't have time, but still they want to publish or submit PhD thesis or MPhil thesis. Then again, they copy others' works wholesale. Some people are afraid of getting failed. Fear of failure drives the people to commit plagiarism. Competition, because you see, I know some teachers who retired without PhD. Why? Because they never felt that it's needed. But today it's not like that. If there is no PhD, you are not considered as a teacher at all. Therefore, pressure from the colleagues, pressure from the parents, then people indulge in this. Some people do not know that plagiarism also is an offense. It may be copyright infringement. And pressure to publish, because just now Professor Ramakrishna said, publish and perish. That is in the context of patents. In the context of academics, it is publish or perish. Publish or perish. If you don't publish, you don't have any marks in your API score for your cash or any other purpose. So you must publish. Because of this pressure to publish, people go for plagiarism. Then some people want recognition. So they would like to be called as authors or scholars. So they go on publishing or copying others. This is one important aspect. Then apart from this, we also have number of other issues. So plagiarism I have already mentioned. It's an act of fraud. And there are instances of vice chancellors indulging in plagiarism. I'm giving the example of Professor B.S. Rajput, Vice Chancellor of Humayun University, and that too in the field of theoretical physics, your own field. He resigned because he was found guilty of copying from a paper published by Stanford University scientists in the physical review. I don't know what prompted this gentleman to commit, but sometimes it happens. Similarly, Kavya Vishwanathan, another very budding youngster, a very good author, but she had to, in fact, undergo a lot of pressure. Both her parents died in an accident. She was a student at Harvard University, UG, and she wrote a book called How Opal Mehta Got Kissed, Got Wild, and Got a Life. But it was found that she very liberally copied from two other adult novels by Megan McCafferty called Sloppy First and Second Helpings. And you just in Wikipedia, you will come across this lot of instances. Then there is another vice chancellor of Central University of Pondicherry by name Chandra Krishnamurthy. Very unfortunately, from law department, she plagiarized a book mentioned in her CV, but which is nothing but a copy from two other books, and those two books were not published. And 95% of the book was part of some curriculum. Somewhere, it was copied. She copied even from a great professor, Professor N.R. Madhav Menon. She said, in fact, I published 25 articles, out of which 24 were not found. You can just, Google, you will find out. These are the licenses, Creative Commons licenses. I don't want to go into that. Last point is that UGC has come out with these regulations. I think as university teachers, all of you are aware, the UGC promotion of academic integrity and prevention of plagiarism in higher education institutions regulations 2018. What is plagiarism? Everything is mentioned here. And we must follow. There must be committees at the departmental level, at the university level, in order to check. And there is a possibility of the PhD supervisor also getting blacklisted, even undergoing imprisonment if such thing happens. This is one important aspect. Then there are many misconceptions about copyright. We must understand that copyright is compulsorily registrable. It's not necessary. Simply you can say copyright reserved, and don't think that any non-profit purpose is permissible. That's not case. Similarly, you can't say that, or I can't say that I'm using it only for academic purpose. Even by copying, I can't make use of. We are not modern day Robin Hoods. Please try to understand that. Then anyway, towards the end, these are some of the orders. I don't want to go into them. Point is very simple. This is a curtain raiser. So therefore, some interest has to be generated in the concept of intellectual property rights on the whole, and in the concept of patents. And this is another, side of the intellectual property rights, namely the copyright. I sincerely hope that I did not rush through whatever I wanted to say, but because of paucity of time, and I know that it is 6:20 or so. Therefore, now it is over to you, Sushma ma'am. If there are any doubts or comments, I'll be too happy to take them. Over to you, please.
Thank you, sir. Thank you very much. You started your speech with the great quotation of a great physicist Albert Einstein, sir. Imagination is more important than knowledge. Really inspiring, sir. You discussed about the modern technology related to IPR. It's related to environment, writing, softwares, etc. Basics of IPR, limited periods of IPR, different forms and classifications of IPR, copyrights are discussed. And especially you discussed about the very important act, Copyright Amendment Act 2012. Thank you very much, sir, for sharing the knowledge with us. Thank you, sir. Thank you very much. Dear participants, will you have any questions? Please write in the chat box. So one of the questions from Partha Sarthi Garu, paintings can protect with copyright?
Answer is yes. Paintings are part of the artistic works. They are copyrightable, and if they are original paintings, certainly they are copyrighted and protected during the lifetime of the painter, plus 60 years after the death of the painter, up to 60 years after the death of the painter.
If you have any doubts, you can post on chat box or raise the hand option. Or they may contact you through email, sir, if there are any questions. Thank you, sir. Thank you very much. A small announcement, Dr. G.R. Raghavendra sir unable to address the participants because of some busy schedule. He will join in the next webinar series. And thank you, sir, for accepting our invitation. And he will join in the next webinar series. Now I would like to invite Mr. V. Rajshekhar Garu, Assistant Professor, Department of Physics, for a vote of thanks.
Good evening, madam.
Yes. Good evening, sir.
Good
Please
evening.
yes.
Good evening to all. Madam, is it audible?
Yes, sir. You are audible, sir. Can you
Okay.
please?
Thank you. So this is Rajshekhar, Department of Physics, Radhagar Nana University. On the behalf of organizing team, I extended my sincere thanks to Honorable Vice Chancellor, Mr. Professor Jagannath Rao Garu, Registrar Professor B. Ganga Rao Garu, and the Principal of University College of Science and Technology, Dr. K. Ramaneshwar Garu, and those who are supported to organize this event. My sincere thanks to Dr. G.R. Raghavendra, Joint Secretary, Department of Justice, Ministry of Law and Justice, Professor Ramakrishna Garu, Chair Professor DPII, Chair on IPR, National Law School of India, Bangalore, Professor G.B. Reddy, Department of Law, Osmania University. And my sincere thanks to Webinar for the technical support. And finally, my special thanks to the faculty, participation, the different colleges of supporters. Thank you. Thank you so much to all.
Thank you, sir. V.B. Reddy Garu and Ramakrishna Garu. Thank you, sir.
Thank you, madam. Thank you very much.
Thank you, sir.
Yeah. I was listening to Reddy Garu.
You.
Always, right, stay back and listen to him.
No,
Wonderful. Thank you.
Very nice, informative webinar series, sir. Thank you, sir. Thank you very much. Both of
Thank
you.
you, madam.
Thank you, sir. Thank you very much, sir.
All the best. Continue with this.
Thank you, sir. Thank you.
Okay.
చిన్ని ఇది వీడియో ఆఫ్ చేయి మామూలుగా మన ఫేస్ రాకుండా పైన పెట్టిలా కాదు ఏం చేసావు
పెట్టి 3 గంటలు పెట్టాను 3 గంటల నుంచి 4 గంటల నుంచి
మ్యూట్ కూడా ఆఫ్ చేయి వాళ్ళకి వెళ్ళిపోతున్నట్టుంది మ్యూట్ లో
ఇప్పుడు ఆడియో వినిపిస్తుందా?
నీ వీడియో పెట్టాను